Let's talk evidence here about those who have been to court as often as many of us have on trumped up, ridiculous charges claiming sexual impropriety and offenses against children, when in fact these were manufactured crimes in search of a target. Um, what's really interesting is those of us who fight in this arena and dealing with the police and prosecution, the politicians, etc., what we're finding out is more and more, and I predicted this a while ago, is that police, as they get more and more desperate to bump up those stats, remember, they're constantly telling us that child exploitation is everywhere and they keep looking for it where it is this much and they keep spending less time in those other areas where it's greater. I have heard from people who work in government that they're doing quite a lot in that area. I'm happy to revise that if they want to talk more about their methods and open them up to scrutiny, which so far they have not. But the point of the fact of the matter is, even if you're spending 50-50 time or 80% 20% time on dating sites, 80% on the dark and deep web, you're still exploiting and creating crimes around those 20%. And those are the ones we hear about all the time. Interestingly enough, we don't hear about the stuff in the deep and dark web, probably because they're trying to keep it secret from the very people who are more skillful than they are in exploiting children versus people like me who are innocent and weren't trying to actually do something. Um, but there's a case that I want to illustrate my points about the exploitation of evidence and what police are doing with that evidence in order to protect that 20% of what I call the gravy, the easy to convict charges. Ones where they don't have to work that hard, they don't have to put very much manpower into it, they get a lot of benefit back on it, and it costs um, a lot, but a lot of those costs are labor costs. And then, of course, we don't ever talk about the cost of exploitation, what it does to all of us. In my case, taking away my pension. In other cases, not allowing people to work for years. The qualitative and quantitative damage to a person's psyche, to their work ethic, to their employability, to their skill sets is monumental when you don't allow them to work. Their sense of self worth, their ability to provide for themselves and their family, and to do what DOC and the government and everybody says that they want to do, rehabilitate these people, which is, of course, 100% grade A baloney. What they want to do is put more money into the prison industrial complex so that they can look like they're doing something, and then everybody wins. The people who go into that complex and feed you, the crappy food, that charge you exorbitant rates for commissary or for phone calls, or who punish you later by charging you the daily rate, which is doable when you leave, of course, if you haven't paid it, or who will go after you for psychosexual evaluation, sex offender treatment. All these things have costs that you have to pay. Okay, they don't have any problem with that exploitation. In fact, they're 100% behind it, patting themselves on the back that they got the baddies off the street. Well, one of the ways they do this, of course, goes all the way back in the chain to the police and their investigation. In their investigation, more and more what we're finding out as they're seeking again a 100% guarantee, which they almost have now, 99.9%, is that they're taking evidence and they are hiding it. They're hiding it, what they manufactured, or they're deleting it. They're not making it available. They're not sending it to you and as the defendant in a file that you can read. They have employed a variety of tactics, including there's something called Tiger Text, where they can text and the text is erased shortly thereafter, similar to what I understand Snapchat does. But in the case of Snapchat, they've gone after Snap Incorporated and investigated them. They're under a serious investigation right now. People think it's safe. It's not. It's not safe. Okay. A lot of these are being infiltrated. And again, we have to have a balance between legitimate law enforcement taking care of children, and don't forget privacy rights, our rights to conduct ourselves in the open, honest forum without having something, being set up digitally with all the AI abilities to make people look and sound like something that they're not. There's little or no work being done to protect people's First Amendment rights, little or none to protect their privacy rights under the Fourth and Fifth Amendments. It's ridiculous what it's come down to. Well, again, back to the original thing. What are they doing? Well, let's take Z out in Arizona. Z is up on CP charges, not his real name, but he's out on waiting for his trial to begin, waiting to see if they're going to offer a plea deal. Looks like they have offered something, but they've moved to dismiss it. Z has, and why has he done that? Because the police deleted the evidence. They deleted their original post where they claimed to be 24 or some such legal age, and then later claimed something else. They deleted all the messages that they exchanged, where they would lead the person on, where they would taunt them, where they would call them names, where they all these little games police do. They don't want that. They might get a judge who is not very favorable to this, who has had some experience, maybe as a defense attorney, although most of them are prosecutors, judges who've had a lot of experience with that. Um, and are friendly to prosecution, um, but they don't want to take the slightest bit of risk to actually lose the case. And the law is weird enough, as I've seen. There are little pockets in there of great uncertainty, and you can see these legal eagles and legal scholars on television for the last several years telling us, "Oh no, they couldn't possibly do this." And of course, the Supreme Court hands down a decision that's reprehensible as well as being incomprehensible in its breadth of disregard for constitutional rights and for basic common sense. So what they did in his case is they did with a Toshiba, a former Toshiba executive that we're working with here in Virginia, where they did not present all the evidence, and they were going to trial a day after MLK Day, and they had a hearing on Friday, and they still didn't have all the evidence. In my case, they sought a continuance. We had to seek a continuance because they dumped a bunch of information on us. By the time we went through the information, we found out it was largely duplicative. These are the games that the prosecution likes to play. And what's really disgusting is they already have all the cards practically. They already have everything. All right. They have the ability to do all manner of things. And the odds are they will grind you down in the process here, and you will be forced into a plea deal, forced to plead guilty when you weren't. And that's what they do. It's not supposed to work that way. The system is supposed to protect the defendant. In fact, ties are supposed to go to the defendant somehow. When there's a case where the defense, it could go, I don't remember what that's called, but where it could go either way, it almost always seems to favor the prosecution. In my case, if you look at the um, body of evidence, okay, you would have to squeeze and look at the nuance of the words as they show up in splashy headlines that some of you write to me about. Well, it says this, you did this. No, I didn't. But I did say those words. They're just taken wildly out of context. And they look splashy and gauzy and nice in headlines, you know? And, if I had been thinking that I would find them in headlines later on, instead of aligning with a person who I thought was a vulnerable teen and doing what I had a little bit of psychological and counseling training, that you don't go yelling at somebody who you think is being trafficked and say, "You got to get away, you got to get away." If I had known that they were going to play those games, of course, I wouldn't have said those things. I would have been thinking, I don't know. But my thought was never, that could be a police. I thought I actually had a vulnerable teen because that was my training that I'd had every year for many, many years. And as I point out, if you go on the Virginia State Patrol website at the time and you look at what they suggest to do if you encounter trafficking victims, well, I did those things. But of course, they're running a sting, weren't they? And the last thing they were interested in is anybody actually doing the right thing. So if you're hiding evidence, if you're deleting evidence, if you're manipulating evidence, as they did with me with a snipping tool, then you're really part of the problem and you're not interested in the truth. And you sure as hell aren't interested in protecting children. And you would think the courts would be interested if it were such an egregious thing as what I just described. In my case, I said something like, um, how are you? And then I'm fine. But this is what shows up. I'm fine. And then how are you? Clearly, it didn't happen that way. Anybody with a modicum of sense would know that that's not how it happened. The court didn't care. The court didn't care because all the court can see is unless you can prove that you were never there and never interacted with somebody that you later found out to be a teen, well, you have no hope. Never mind what you said. They'll tell you what you said. They'll tell the judge what you meant by saying what you said, and the judge will believe it. And if you don't believe me, investigate it yourself. You'd be amazed at how many of these cases go sideways when you're sitting there and just ask some of the people who were burned by courts. Look at, go down to the lower court where I first ran into and had myself um, first shocked by the reckless disregard for children that they actually have in there by hiding behind procedures and laws and that and protecting their own. That's a big one. Protecting their own integrity, their own asses. That's what they're most interested in. So again, follow up on evidence. If you're fighting one of these cases out there, demand everything. Demand everything. If you know there's more, demand it more. Claim that there's more. Go after them for more. Okay? And don't wait on this. And look at it very carefully. And secondly, hire a forensic analyst to look at it. It's worth the money. You have to win at the trial court. Don't do like the rest of us did and have faith in the system. Don't look at the rest as the rest of us have done and say, well, no, this there it doesn't say. I say over and over again, I'm not interested. They don't care. They're there to convict you. That's what they're there for. They're not there to find a reason not to convict you. And the judges, right along with it, don't believe one of them when they tell you they're not, because they're going to first distill it, put it through the filter of, am I going to look really awful if I let this person off? Will I be reversed on the appeals court? I better watch this very carefully. We had a judge in the Ryan Pick case who did not read the clear language of the statute, which explained what wiretapping was. Okay? It's an old term for a new concept that's been expanded since 1986. And that concept is if somebody is listening in on your calls without a warrant, that is a violation of the Fourth Amendment. Okay, but they're getting away with it over and over and over again. So this is just a little bit of a capsule summary on evidence, citing one particular case, two if you include my own, but it's happening everywhere out there, folks. You got to understand it. You got to believe it. Okay, get educated on it because it's only a matter of time with AI and digital technology that you could be an unwitting victim too. For ICAC Unpacked on the 20th day of December, this is Norman Michael Asian. Have a good day.